panel, attorney Vanita Banks, master's in tax, cybersecurity expert, and of course, Milton from LA, famous Representative Rodney King. But we got a really big show today because we have another historical first in American democracy. This week, the former president of the United States, AKA Mr. Crime Wave, was indicted in Fulton County, Georgia. It was an indictment that is historic in a lot of ways. One of the interesting things about the indictment is that the lawyers that represented the former president of the United States also got indicted. And they're charged with racketeering. The introduction to the indictment states as follows. Defendant Donald John Trump lost the United States presidential election held on November 3rd, 2020. One of the states he lost was Georgia. Trump and the other defendant charged in this indictment refused to accept that Trump lost, and they knowingly and willfully joined a conspiracy to unlawfully change the outcome of the election in favor of Trump. That conspiracy contained a common plan and purpose to commit 2 or more acts of racketeering activity in Fulton County, Georgia, elsewhere in the state of Georgia and in other states. Wow. And when you look at this almost 100-page document, they give specific examples, but it's recorded. It's their voice, the video surveillance, the image, the likeness, email, written correspondence. So everything they put in the indictment, they had the evidence of the person incriminating themselves. And to start off, our famous defense lawyer, how in the heck do you defend the case when everything is recorded?
Well, I've seen a few police officers get off with the recording of an incident that was contrary to their action. So I say that to say that you say, how do you defend that action? You defend it with the popularity of your accused. You defend it with the dislike of your accuser. You got all kind of components that go into a trial. You defend it with a jury nullification approach that, yeah, the law may be there, but for this particular incident or situation, the law should not apply. You defend it with, like I said, the popularity of your defendant or defendants or their cause. Now, getting to the issue in question, I haven't heard the evidence at this time. So he starts out with, contrary to how you and I enter a courtroom, like they say about cops. I know attorneys who represent cops. When they walk into the courtroom, they are presumed innocent. When the average one of us walk into a courtroom, we are presumed guilty, and we have to prove that we're not guilty. So there are a lot of things to consider about the defense in this case, Nathaniel, other than our belief that he is obviously guilty because it's tape. They could have been discussing their disagreement with the election result, and they could have been discussing what they thought about the election result and what they think they should do about it. So I don't know how concrete that tape recording is to say that they did a criminal act.
Wow. Attorney Banks, I don't know. I, like most Americans, heard that infamous tape between Raffensperger and Donald Trump talking about find those 11,480 votes, go out and find the votes. Meanwhile, his lawyers went to a county to get the voting machine, apparently to alter the voting machine in a Republican county that went 75% from Trump. I guess they want to make it 100%. I don't know. But I don't know, did you watch any of this play out on TV? Or I saw it repeat itself repeatedly. This call must have, I don't know, about a whole week, I heard about 20 times.
Absolutely. At the time that this call was made, we saw this coverage on television repeatedly. The former president states even today that that statement, that call was a perfect statement. So he's still alleging that there was really nothing wrong with that call. And we know that Fani Willis has in her indictment, it's clear to see how thorough and methodical her approach has been in an over 2.5-year investigation, as she has laid out in a 41 count indictment with 19 named defendants, a 97-page total indictment where she names, and it's stunning to see the number of attorneys that are named in this indictment. I counted at least 5, and there may be even more attorneys that have been included. We know that in Georgia, their RICO racketeering law is broader than the federal statute. And she's skilled in utilizing that law against perpetrators of crimes in Georgia. And she states that these defendants participated in a criminal enterprise with other unnamed individuals, both inside and outside of Georgia, with the illegal attempt to overturn his 2020 election loss and stop the peaceful transfer of power in our nation. And so we see with her indictment, her approach versus Jack Smith's very narrowly tailored indictment that we saw the other week. So it's going to be interesting to see how the evidence is developed, as Attorney Grimes states, and how these two charges or these two cases move forward. This is, of course, the 4th indictment of the former president on almost 100 different counts.
Add on to that, what I said, you got a number of defendants. I don't think she's going to try all 19 of them at the same time. But if she does, Nate, I'm gonna hide behind this one and hide behind that one. I mean, it's a difficult thing to accomplish, I think, to keep people straight, keep the evidence straight. Who did they say it applied to? I tried a case in Louisiana where they don't let the jurors take notes. They don't let the jurors take notes. I don't know what the rule is there in Georgia, but you got all kinds of things that go into a trial. You got the number of the defendants. And if the instruction I'm familiar with is that if the evidence indicate that the accused or the person is guilty, and the same evidence indicate that they could be not guilty, then you got to give that accused the benefit of the doubt and take the decision that the person is not guilty, because it is not proof beyond a reasonable doubt.
Well, okay, to answer your question, here's what she did that was brilliant, I thought. She set forth what happened each day, each time. Like, for example, the most interesting person indicted was Travion Cuddy, K-U-T-T-I. She was the publicity person for the single formerly known as Kanye West, now named as Ye or Ye. It says as follows: it's Act 115 on page 53 of the indictment. Now, each one of these indictment allegations, they go each day and they give time. So in other words, they have the physical evidence of exactly what they're doing because they're recorded calls. So they say on Miss Cootie, on or about the third day of January 2021, there was several people named, but and Travion C. Cuddy placed multiple telephone calls and sent text messages to each of the individuals involved in the conspiracy, including at 7:48, they sent one to Harrison William Prescott, placed a call to Ruby Freeman at 7:48 p.m. At 7:49, he called her a second time. At 7:49, Travion Cuddy placed a call. So they go through all these recorded calls and they meticulously put the date, time, person, and they got emails, phone recording of each of the phone calls that they're making. And so, but the most fascinating part about this, counselors, is Travion Cuddy. I was thinking, why would Kanye West be involved with trying to bribe Ruben Freeman in Georgia on the election? Of all the dumb things you could do as an entertainer, I don't get that part. I know he ran for president to help the Trump campaign, but why would he send somebody down to do something so outrageously dumb?
Well, of course, he's been a long time staunch supporter of the former president. That doesn't necessarily, that isn't necessarily a rationale, for his actions, but it's interesting, the Chicago connections to this indictment. You've mentioned Travion Cuddy, who is Kanye West's former publicist. She's also a stylist of several people here in the Chicagoland area. But the outrageousness of going to Georgia, and as you said, much of this is tape recorded, going to Georgia and meeting with election worker Freeman, who testified, with Congress regarding, how she had been abused and harassed. But to meet with her at a police precinct and present herself as someone who could protect this election worker or help her, and then try to pressure her into falsely confessing to election fraud. I mean, these actions are just, outrageous. And then we have Harrison Floyd, who served as the director of Black Voices for Trump. And he's alleged to have arranged a meeting with election worker Ruby Freeman and Chicago-based publicist that we're talking about, Travion Cuddy. So it's just, but to your point, Attorney Lee, District Attorney Fannie Willis has been very methodical in her investigation. She's laid it out, and she essentially, has thrown the book at the former president.
Wow. Well, the most fascinating thing about this Cuddy was they set forth the following. Travion Cuddy on page 54, Conspiratorial Act 116, right? So, and they set forth these each date and time. So on January 4th, this guy, Harrison William Prescott Floyd, allegedly, he picked her up from a train station in Fulton County, Georgia, for the purpose of attempting to contact Ruben Freeman, the election worker. And then Cuddy then went to Ruben Freeman's house that same day in Cobb County, Georgia, but she was unsuccessful. But she spoke to her neighbor and said to her neighbor that she was, quote, a crisis manager attempting to help Freeman before leaving Freeman's home. Then she placed a telephone call to Ruben Freeman and stated that Freeman was in danger. This is on January 4th. Travion Cuddy then stated that she could help Freeman and requested that Freeman meet and speak to her that night at Cobb County Police Department precinct in Cobb County, Georgia. So they traveled to the police department. She met and spoke to Ruben Freeman for approximately 1 hour. Now, Harrison William Prescott Floyd joined the meeting by phone. And they told her she needed protection and purported to offer her help. So
like they were interested in protecting her and looking out for her. How did they prove the intent in their mind, or this person's mind, was to break the law?
well, what they did is that they put this carrot out there, and they tell them in paragraph 120, they wanted her to say that there was fraud in the election process in Fulton County. So they were trying to say that, yeah, the votes were double counted in Fulton County. There was some irregularity. They created some ballots. They wanted something to say there was wrongdoing, and they wanted her to do an affidavit that was false. The affidavit would have been a crime. And so they're saying that it was she's charged with solicitation of a false statement. So they were soliciting her to make false statement. And that's a pretty low standard because they got it on recording, exactly what she said. She said, you know, you need to say this, you need to say that, and we're going to give you protection. We will take care of you.
I'm just being a devil's advocate. I'm telling this person to say that because this is what I believe happened. And I know this person knows that. I mean, you say it enough time, jurors, somebody may believe it.
Well, as we know that those who are staunch advocates of the former president, they have a firmly held belief, as Attorney Grimes is stating. So their belief might be wrong to others. It may be in fact wrong, right? But it's still firmly held. And so does that constitute a conspiracy, Attorney Lee, to commit forgery or to prepare and file false statements and writings as alleged in this multiple 41 count indictment? This is a very impressive indictment from my perspective. And it's very broad. It's when you contrast it to Jack Smith's indictment, which is very, very narrowly tailored with, I believe, 4 counts.
That's an excellent question. Now, before I answer that, callers, our number is 833-653-3529, 833-653-3529. Let me answer that this way. You went to a bank and you deposit a few $100s. So one day you decided that you have $1 million in the bank, not $200. So you go to the bank, you take your gun and say, give me $1 million. It all belonged to me. And so at gunpoint, they give you $1 million. So you could have a belief that you have $1 million in the bank and you only deposit $200, but you're still just as guilty from my standpoint of attempting to rob the freaking bank. So in this case here, we have a presidential candidate who lost the popular vote by 7.1 million votes. In other words, in American history, this president ran twice. He has more votes against him than anybody in the history of politics. So he decided, even though I lost the electoral count by about 70, but the popular vote by 7.1 million, I won the election. So what's the difference, Milton, between that and thinking that you could take your money out of the bank with a gun?
Because for the last week, I've been walking around mumbling to myself that they better give me my $1 million. This bank won't give me my $1 million. This is my money. I am tired of them taking my money. Do you know they won't give me my money, James? I got to get my money. And when I go in there with that gun, I have formed the belief, and I have found, and I have exhibited my belief that I got $1 million in this bank. Now, it might be a defense of insanity. At the time, I was insane. I didn't know what I was doing, yada, yada, yada. But I didn't commit no crime if I'm insane, because I'm not guilty by reason of insanity. So, Nathaniel Lee, I think in this case, these boys got a little defense up their sleeve.
Well, of course, their main defense, which we're, hearing every day, is that this is a politically motivated witch hunt against the president, the front runner in the upcoming 2024 election.
And a question, Vanita, you finished?
Yes.
They haven't come to change of venue and all those issues. King was taken out of LA to Ventura County, to Simi Valley. Not guilty in the face of all that evidence. I mean, where is this case going to be tried?
Great point, and a great transition to talk about, we're hearing that the case might be removed to federal court.
Who's going to be the jurors, Nathaniel? We do understand that some guilty people walk off if they're in a favorable court. So
every single day.
Well, here's my problem, Counselor, with Mark Meadows' motion. He personally traveled to Fulton County, Georgia. He personally got inside of the voting process, which was precluded from public purview. So he actually committed a crime that he violated the statute by entering the voting which he was not allowed to do. So he's saying that it's a federal issue, but that's a state crime. So I don't understand. I heard some of the political pundits say that but then if you're in Georgia, you shoot somebody, you could be charged in a state crime and maybe a federal crime, but the state crime could still proceed. And that's the problem I'm having with this. The racketeering statute they're charged with is a state crime. So I don't know how you could then move that to federal court, because the federal court could, in theory, charge you with a federal crime also. So part of what they did would also be a federal crime, but the state prosecution could probably still go forward, to my understanding. And that's what I'm puzzled about.
Okay, but when I say, how do we know if it's going to be in a county that is, how do we know that it won't be changed to a county? County still sticking with the state prosecution that would be more favorable for the defendants. Can't they transfer it to another county because they think that the people in this county, as shown by the polls or by the jurors who come in, that they can't be fair to the defendants because of all this publicity, and they get it switched to another county in Georgia?
Well, there's a couple ways you could do that, though. Don't forget that if you think that you can get jurors in one county, you could leave the trial in that county and just transport jurors from another county into the county to sit in the jury panel. So
That's still changing your jury veneer that's going to look at this case, right?
Yeah, but see, the other county that they committed crimes in, except for the one Republican county, they were big Democratic. See, unfortunately for these defendants, all of these, about 80% of the critical acts happen in Fulton County. And then a small portion is DeKalb County, which is highly Democrat. And then maybe 2% in the Republican county. So we look at the counties that's occurred in,
we're not looking at the counties that occurred in. We're looking at the right of the defendants to a fair trial. And I am saying that this county, this prosecutor has permeated this county with hatred for the defendants to the extent they can't get a fair trial. Poll the jury. So now let's move this way down to southern Georgia or western Georgia. I don't know where they move it to, but get out of this county because my clients can't get a fair trial because everybody's made up their mind here because of their star prosecutor and and press conferences. So every juror that come in here, at least half of them say, yeah, I believe the evidence indicates that they're guilty. So I can't get a fair trial here. So let's move it somewhere up in the mountains or I don't know.
Or here's what I call on to know, counselor. If Mark Meadows is successful in getting his case moved to federal court, does that qualify him to have a public defender or paid legal defense?
Well, you do have the alternate defense panel in federal court as well as state court. So you would have an attorney, if not the public defender, because there's a conflict. You got a group of lawyers that the federal government pays to represent the accused in federal court.
Now, the second part of the question had to do was, since he's saying he was a federal employee at the time serving the president, why wouldn't his case be in federal court? Now, that to me is very simple. If you were speeding in Atlanta doing 100 miles an hour, would you get a speeding ticket in Atlanta or would you get it in DC?
No, I think that you can get a state cause of action or a crime, even though you are working with and supporting a federal employee like the president. You still can commit a state offense.
Arguably, yes, you can, but there are many bases for removal of cases. One is diversity of jurisdiction,
Right.
but specifically Mark Meadows is stating that he's citing, the federal removal statute, section 1442, which allows a civil action or criminal prosecution to be removed to federal court if the lawsuit or prosecution relates to conduct performed under, quote, color of his office. And so he's arguing that any actions would have been under color of office, and therefore his case could be removed pursuant to the federal removal statute. For its section 28 USC 1442, where federal officers or agencies are sued or prosecuted.
Okay, so he can move it to federal court. The law is unusual in a lot of places like Illinois. The defendant is only entitled to a jury trial. At least when I tried a case there some years ago, not the government. So you can try a case in front of a jury up until the last minute and then decide, well, I want the judge to decide my case. Right, Vanita?
Well, right. You've actually tried the cases here, so I'm going to agree with everything that you say.
No, don't do that. No, but that was my experience.
In that regard, in terms of your experience, so if I'm representing the former president and these other defendants, yes, I'm going to try to remove the case to federal court, where I would believe there would be a more where I believe there'd be a fairer, if you will, prosecution of the case.
Well, here's a problem that, let's not forget this. The young man that were brutally murdered there in South Georgia, they were prosecuted in state court, and then they're prosecuted in federal court. When you look at the allegation in an indictment, he committed acts in furtherance of this conspiracy that also would be an independent state crime, but also be a federal crime. So in theory, he may be asked for something that may end up being double prosecution. I think that when you look at these allegations against Mark Meadows, the U.S. attorney there could actually file criminal charge under the federal statute that he violated, that they already have the physical evidence.
And it not be double jeopardy. I understand.
Well, no, he did commit acts that would be federal in nature, but he committed acts that are state crime.
Absolutely. I mean, when he took part in the, that January 2021 phone call that included Trump and the Secretary, of State, I mean, he's being accused in this indictment of breaking, state law as well.
Yeah. So let's go to the caller. Pierre, you have a question or comment for us today, sir?
Good morning. Here's my question. I'm talking about the lesser defendants of people who aren't the big names, but charged anyway. that may not have the means of an attorney, of some of the attorneys or other, they get the do they get to use the Georgia public defenders to help, like say, for example, the 2 black defendants? I can't imagine. I heard a discussion on another radio program out of Georgia, attorneys talking about they charge upwards of $300,000 or $1 million to represent these people. They don't have that kind of money. So what do you think? I think their chances to go,
Pierre, if they
go with
can't,
the public defender.
well, if they can't afford a representation, then the government will probably appoint them a defense lawyer. It'll either be a public defender or somebody from the Alternate Defense Association. I mean, that's what the law is out here in California, or what the situation is, but we do know that in the South, they may be short on the funds sometime, a little shorter than in some other states, but I think Georgia has sufficient ability to appoint them representation.
Mm-hmm.
Absolutely. And I don't think, although District Attorney Willis states that she's going to try all of these defendants, all 19 at the same time, I don't think that's going to happen. She also has requested that the trial to commence in March of 2024. That may or may not happen. By that time, however, I don't believe there's going to be 19 defendants. I believe some of these are going to flip, right? And that they are also going to plead out, although the Georgia racketeering statute does have, quote, if convicted, mandatory minimum. So that's going to be a reason for people to think very seriously. And to your point, Pierre, some of the lesser known and affluent defendants may encourage them to take plea deals. I think that's likely to happen.
It all
Yeah.
depends
Is
on
this
white
case?
collar crime.
Is this a case where the prosecutor really doesn't need anybody to flip because of all the evidence she got?
Well, according to Mr. Lee, they shouldn't go to trial for sure with the evidence they have lined up, but I'm sure some of them are bold enough to go.
Well, on each of the allegations, about 80% of the allegation made in this length indictment is based upon what the defendants themselves said or videotaped or recorded. So their evidence is based on what the defendant himself is recorded as doing. And like for example, on December 22nd, Mark Meadows, he went to the voter verification of signature in Cobb County. And so when they're doing that, it's not open, the audit process is not open to the public, but he somehow used his influence of being a White House person to enter the premises and attempted to force himself into the audit process inside of the area. And then they end up removing him, but they were saying that was an act in further of his conspiracy, but he's recorded doing all this with cameras. And so what they're saying he did, we know he did it because we got him on camera, and that's the problem. And with these, and then he then met with the phone call with the 23rd day of December. And so Trump and these guys had multiple calls, all recorded. And that's the problem. We're trying to defend this. What they accuse him of doing, they wrote in the indictment exactly what they said on the recording. I think that's going to be, let's go to and take another call now. Okay, Carl, you have a question for us today.
Hello?
Hello, you have a question. Go ahead.
Yes, I do. Yes, well, you know it's really sad when your lawyers need lawyers. And now you have Rudy Giuliani saying that he's broke and he needs a lawyer. Well, in the words of that famous philosopher Sammy Davis, if you can't do the time, don't do the crime. And as far as Kanye and his minion who are involved in this, I think one of you kind of touched on it earlier. Kanye and his people can easily say, well, they're not mentally stable. We know Kanye is not mentally stable, with some of his past comments. So obviously there's a two-tier justice system, because if it was you or I, we'd be behind bars right now, but yet Giuliani, Trump, and some of these other bums, and as far as the two black folks who are involved in this code, I don't call them black. Gentlemen, I'm sure when you guys take out the trash, it's this little animal that roams around in your trash, and that's a raccoon, and that's what these two black folks who are associating with these bigots and these fascists, and that's what they did. This is fascism at its worst. These people plotted a coup, and any other place, they'd be behind bars. We saw what happened to the January 6th bums when they tried to storm the Capitol. Some of them are locked up or waiting their trial dates. So what's going on here? Why is Trump not behind bars or in handcuffs or in an orange jumpsuit somewhere? I mean, you guys are the attorney. You gotta explain to me. I mean, obviously, I'm not a lawyer, but I know that something ain't right. If I did what they did, I'd be incarcerated.
Counselors?
Well, you see the justice system in operation. Some are treated better than others. You got a poor man with no money coming to court. He can't bail out. He's got to take a deal or he's going to do some suffering time before his trial. You have the well-to-do coming. They can bail out. Society say they're not going to be a danger to the community and they're not going to run. So they can remain free until they have a trial. So that's been
but obviously these men are domestic terrorists. I mean, let's call them what they are. They are domestic terrorists. Just, I'm not worried about Al Qaeda. I'm more worried about Al MAGA. You know what I mean? So, and as far as these two black folks, I'm going to say, I might get barred from this show. They're coons. I mean, let's just call them what they are. I got more respect for four-legged coons than I do for the two-legged coons, like Clarence Thomas, Tim Scott, Candace Owens. So these people, if you want to hang out with white supremacists, I ain't got no use for you. Have a nice day.
Well,
this won't be the first time in history traitors and people who were against the government have even been raised up to heroism. Look at the Civil War, look at Robert E. Lee, and look at all the Confederate generals and army officers who were traitors against the Union. They are hailed today as heroes. So Trump and his guys are free because a lot of people think they're innocent and that they are really representatives of this country. So it's not as simple as you may want it to be, sir.
Yeah, and I never used terms like that. So in the future, callers, try to refrain from the name calling, because you have some other adjectives you could use. Like, for example, is stupid. I mean, that's acceptable, but you shouldn't use racial names, though, in any capacity. But in any event, but one of the things that is present on this indictment is that they go through each of the dates of what occurred. And when they go through the dates, then they tell you about the documents that applies. Like, for example, on December 23rd, he called Francis Watson and matters arranged for the call. And so you got the President of the United States calling the investigator for the voting process. And then on December 23rd, Eastman sent an email to Kenneth Cheeseborough. So the grand jury people obtained copies of the emails that they submitted to each other in furtherance of this, what they consider to be a criminal conspiracy. So each of the allegations go by date, and they got his draft. Now, what was really weird, they got his original email and his draft email with edits. Now, I was looking at that, I'm thinking, did they subpoena the computer and download this from the, it'd be interesting to see how they put this on, Milton, because I'm looking at the evidence they have their drafts of they wrote on their computers. So I'm thinking the only way they could have done that is that they must have gotten copies of their hard drives or something.
Or their email, whatever you call it, printouts from somebody. So they got all this evidence, Nate, but I still say now the evidence is up to a matter of interpretation of why I wrote what I wrote, when I wrote what I wrote. And sometimes, you just got to look at it objectively. Can this evidence slam dunk prove that they are guilty of a conspiracy, or is it less than beyond a reasonable doubt? I don't know.
Mark Meadows. Sorry, Attorney Grimes.
No, go ahead, Vanita, please.
Mark Meadows in his filing and, including his motion to remove, is stating that that nothing that's being alleged in the indictment is criminal. Just rejecting, the detailed documentation and records, Attorney Lee, that you are, summarizing on, many of these counts. And he's asserting in defense that arranging Oval Office meetings and contacting state officials on behalf of the president and visiting a state government building and setting up a call for the president are things that you would expect a chief of staff to do.
But the key word that repeatedly in the indictment is the word false. They made false statements, false allegation. So all the things he's saying he did, that they recorded, they were false narrative of what the evidence was, like by saying that they had dead people voting, that people, find 11,000 some odd additional votes. These were all statements that weren't true. And so, but the way they're charged is for making false statements in furtherance of a conspiracy to overturn the election. So individually, if he were independently made a single phone call, nothing else happened, and said, make a single false statement that says, Trump won the election by 11,000 votes. Don't you agree? Okay, that wouldn't be a crime. But what they're saying that this is part of racketeering in a conspiracy, and they have a total of, let me see, they itemized in the indictment a total of
161 criminal racketeering acts.
Yes. And so on top of that,
you only need two. You only need two to constitute, the criminal enterprise and the pattern of criminal activity.
And then some of the acts they did happened. What was interesting when they went appear before that grand jury, Robert Cheeley, they say he committed perjury, for example. And so he testified. I guess Milton is a good thing that they have the Fifth Amendment. So he goes before a grand jury and he is charged with perjury for lying to the grand jury. He could have just taken the Fifth Amendment and he wouldn't have the perjury charge against him.
I think about, as you talk, Nate, the times that I've argued with somebody about the outcome of a football or basketball game and how the referee cheated and how they should have called an interference and then they'd have stopped the ball and this team would have won or that team would have lost. And yes, we won the game, even though the score says that they won the game. And we won the game because this referee didn't call a foul, or this person didn't do this, or he was out of bounds. And that's our right to disagree. So unless you can show a real nefarious intent on my part when I'm making this statement, other than it being a belief of mine, I think I have an argument of interpretation of my behavior, my acts, even though it goes contrary to what you want to say and what you think the evidence shows. I have a reasonable interpretation of my actions that indicate it wasn't against the law. So I think we'll have to see what happens with it.
Yeah, but is the old axiom, ignorance of the law is no defense? Is that still true today?
Depends on who's called ignorant. It depends, bro. I'm sorry, I can't agree with you on that. You know, I mean, I believed in what I was doing at the time. Otherwise, I wouldn't have done it out in broad daylight, noontime, in a public place. I am not hiding anything. I am not thinking I'm doing anything
Wrong. It's all documented.
right.
You know, I mean, I picked up the phone. Yes, I did call the Secretary of State. Yes, I did say that I need to find, quote, 11,780 votes. And there's nothing wrong with that.
Doing
I mean,
my
that's-
job. I work for the White House. Shit. Shoot. I'm sorry.
That's the argument, Attorney Lee. We'll see how successful it is.
Well, was interesting though is that the indictment, I keep saying this, they keep saying what they're saying was false. So the first issue is that was the statements they're making true or false? And to prove that it's false, in their indictment, they've certified the voting results. The Secretary of State does an affidavit saying that it's accurate to the best of his knowledge. So in order for them to prove that what they're saying was not false, it seemed to me, I'm not a criminal defense lawyer, they had to prove that the people in Georgia, the Republicans who certified the results, were making false statements also. Now you got to remember, in the congressional down ballot races, the Republican did fine. It was only in the presidential and the Senate races that you see the adverse results. In the last year, of course, the Senate race, but the point I'm making is that they have people win the congressional seat, and the voting trends show that in those seats, those candidates got more votes in those Republican districts than Trump did. So does he go back and say that the Republicans that got the more votes than me, their votes are false also? And that's what my concern is, that how far does this falsity go? How do you turn around and try to prove that it's true? Now we have several callers now. Let me get one real quickly. Hey, caller, you have a question or comments for us today?
Yes. This is Guy calling. Good show. I wanted to know if Attorney Grimes knows anything about Attorney Leo Terrell. I've seen him on Fox News, and he seems to have taken a 180-degree reversal from the time he was on the OJ trial and so forth. What is his story?
I don't know what Leo's story is, sir, except that he has sometimes a tendency to disagree with mainstream interpretation of things. He's a likable person personally, but I cannot explain why he says some of the things that he said. That's the best I can say it.
Does he have a record like that?
Well, he's a Republican, and you know, I mean, politically, he's a registered and he's active Republican. I'm not sure, you know, we, in terms of ideology, in our city, for example, we have several African-American, prominent African-Americans that support the Republican candidate for mayor, right? And somehow they feel that this individual who has a corporation, when you looked at the website before he went, he hired no African-American at all. He got like 40 employees, not a single one is African-American. So now he's going to solve the problem of our community, and they agree with him. Now, these are prominent folks who feels that way. And they have a right to feel that way, but I'm saying is that the evidence just seems to suggest otherwise.
I think this gentleman is saying that Leo Terrell, though, at one point in his career and his image or his place, he was supportive of minority causes. And he may appear now to have switched that allegiance or that position. And I can't explain what has caused his transition or transformation. I haven't talked with him about it.
Wow. Also, DA Fannie Willis, it's been reported that her father was a leader in the Black Panther Party. Do you know anything about that?
I don't know anything about that, but you mentioned a subject that is dear to me. I think, Morris, did you say something about that at the beginning, Vanita? There's a CNN special on Sunday evening about the original Black Panthers, and it was a Black battalion in World War II that was not acknowledged, has not been acknowledged, was not given credit, because as described by Morgan Freedom, they were the tip. If you look at an arrow, they usually were the tip of the arrowhead going into combat, which means they were put into combat first, and then the white troops followed behind it. So it's I'm looking forward to looking at that documentary Sunday night.
I want to shout out to Guy, a fellow Shortridge High School, Indianapolis alumnus, and say that I have been reading about District Attorney Fannie Willis, and I understand that her father is in fact was in fact a member of the Black Panther Party, and that she grew up attending Black Panther meetings. I might have read that he was an attorney.
Let's make something real clear, that so we don't rewrite history.
Mhm.
Back in the civil rights days, everybody, let's not forget this. We had segregation. We were denied the opportunity to have regular jobs, denied the opportunity to vote like white citizens. These civil rights groups were formed to try to elevate the status of African America to have the same rights as people that were not of color. So they were characterized in a negative light by the media, but they forgot about the fact that during Jim Crow and stuff like that, we had African Americans who were murdered, raped, and otherwise
lynched.
Yeah, so I don't think that necessarily mean anything significant, because she's her own person, and that's how she should be judged. In this case here, the evidence that they put together, they got the defendants themselves on tape. Email, their own writing is what they're charged with. And so let's not forget about what the evidence is in this case. The evidence in this case is not based on hearsay, except when they're talking at the White House and the White House staff people testify before the grand jury, where it's not recorded. But that's just a very, very small portion of this indictment. And so I think I would predict that if this case go to trial, unless there's some train wreck, that these people are probably going to be found guilty. My prediction. I could be wrong. But anyway,
Have you ever, as attorneys, have you ever seen such pretzeling going on with the judicial system?
Milton maybe could answer that.
I didn't understand the word you used. What?
Pretzel, like twisting into different contortions, like a pretzel, different tactics that are being tried by the
Yes.
defendants' attorneys.
Yeah, usually a case, you got two sides to a story. Sometimes you got 3, 4, 5 sides to a story. And as many sides as I can find or create, I'm going to put forth in my defense to this story. And all I'm saying is that in light of all of the evidence that Brother Lee is saying is there may be several interpretations to this evidence that we got to remain open for.
Okay, well, thank you everyone for calling in today. We've reached the end of our allotted time on our show. I'd like to thank our superstar panel. I'd like to thank all our call-ins today. We will be with you next week with another exciting set of news, and we'll do a follow-up on this story because this is just the beginning of this. This is going to be a lengthy process. We have the former president with 4 different venues being indicted. Never seen it before. We got lawyers charged. So it's going to be a fascinating legal set of events that will transpire over the next year. And it's all going to be the first time in American history. So stay tuned. Thank you, everybody, and have a blessed day and have a great weekend. Goodbye.
Thank you.
Thank you.